to Disputes Decoded with me, Chris Campbell. This is an ArtTech podcast series where we will take a deep dive into a variety of legal tech issues by way of candid interviews with selected subject matter experts. Technology has, and always will, have a profound impact on dispute resolution. And in this series, we'll give you insights into where we're going next. We will demystify complex concepts, decode the jargon, and provide practical insights on advancements across the legal tech space. Join us as we navigate this future where law and tech converge. Welcome to Disputes Decoded, where we download the field of arbitration into the future. This is a welcome back after our first two episodes to kick off this new initiative. And for you newcomers, welcome to the show. If you've enjoyed what you've heard so far, please share the show with a friend or colleague and leave us a comment or review on your podcasting platform of choice. It helps us out and it helps others find the show. In our first two episodes, we talked about artificial intelligence, AI, what it is, what it means, and the different forms it takes around the globe. This time, we take a different conversation forward with two special guests, Ms. Racheal Muldoon and Mr. Ferdinando Samaria, who are going to talk about regulation of AI, potential use cases, in particular in finance and general application overall. And just like last time, this episode will be the first half of the conversation, and the next episode, episode 4, will be the remainder. So sit back, relax, and enjoy the show. Racheal, Ferdy, welcome to the show.
Hi, Chris. Great to be here.
Racheal is an internationally recognized barrister in the intersection of technology and law for Maitland Chambers in London at Lincoln's Inn. She advises her international and domestic clients and represents them in court and mediations across the range of matters encompassing data protection, intellectual property, insolvency, and consumer rights. Ferdy is a computer scientist with extensive experience of the financial industry, particularly in the areas of trading and risk management. He currently focuses on applications of artificial intelligence, decentralized finance, and cryptography. Great to have you here. And so, look, we're now stepping into 2024, and what we're going to talk about today is this thing called AI, artificial intelligence, which has only been around like a year. It hasn't existed before that. And we talked about what artificial intelligence is, definitionally, and the different forms which it could take on our previous episode. I guess maybe a place we might want to start, and I'll put this to you first, Racheal, is when you think about artificial intelligence, I guess, what do you think of first? And we'll sort of use that question to both of you to sort of guide us to our conversation today.
Absolutely. Well, based on my practice since 2017, really, I've been looking at algorithmic decision making. And that is really the thrust of it for me. It's what is input into a model of some description and what is the output, whether that be a prediction, whether it be a whole sense of prose or a poem or something of that nature. Now that's very much generative AI, Gen AI, as the world has come to know it in the past year, but really diluted and distilled to its fundamental principle, its algorithmic processing of data sets. That would be the generalization.
Well, you just distilled that very well, Racheal, and I think that's better than most could. And, I typically see a page-long definition when I look at it. Ferdinando, how about you? When you hear the terms AI, what do you think comes to mind for you?
Okay, so I have worked for over 20 years in the financial industry, but my actually formal academic training is indeed in artificial intelligence. I did a PhD in AI when it was not a particularly trendy subject back in the early 90s. And of course, I'm very pleased that now it's become such a popular, commonly discussed area with a lot of interest and focus even in, generic media. So not just specialized, let's say, material, but actually the wider public in general. AI is a very complex and ever-developing discipline. So putting a definition is not immediately obvious. It's interesting that Racheal mentioned Gen AI, which is literally a few months old. Later on, we're going to talk about regulation, and this area is so sort of dynamic that if people had written regulation a couple of years ago, they would have not mentioned Gen AI. And of course, now Gen AI is one of the reference topics in for example, the EU AI Act, etc., etc. So it's an area which is always in evolution, and where perhaps not always, the definitions are not always aligned, but it's certainly an area of amazing interest and impact, of course.
We could very easily, from those answers, sort of jump into another discussion about what AI is. We may get into some of that more, but what I really want to focus on and do a little bit of table setting as we get into this conversation today is, when we say how is AI, what we're really getting at is something you just mentioned, Ferdy, is we know that AI technology exists and that encompasses a number of things. But the question sort of becomes, what are the rules of the road for using it? I mean, are there ethics in using it? Are there regulations in using it? And those are sort of the questions that we've been wrestling with as not only a legal community, a business community, a technology community, all of those things across the globe. I guess the first question might be, sticking with you for just a moment, Ferdy, and then we'll come to you next on this, Racheal, is what do you think about the current state, or I guess types of AI regulation? And I guess I'll add a compound to it. Does it need to be regulated at all? Well, starting off with a controversial one.
Well, I'll start from the controversial one then. I think the potential impact of AI is so significant that regulation is unavoidable, and it's actually quite desirable. Then, of course, the question becomes, how exactly do we go about regulating something so complicated? There's a lot of material out there. Various geographical areas around the world have been doing quite a lot of work. There have been attempts at coordination, explicitly or otherwise, but I think people have been working on their own for the most part. Having said that, when you look at some of the basic material that has been made public, I think there's a lot of common sense and good principles being discussed and applied. Of course, the devil will be hiding in the details. And I think, realistically, I think the only piece of regulation in terms of advanced stage of approval that we have at the moment is from the European Union, which recently got the green light to go ahead. Of course, it's not law yet, and there's still a little bit of work to be done, but it's certainly a good initial framework that will most certainly become a benchmark by other jurisdictions as well.
Okay, so I think if I hear you right, you're saying that it's something that's desired, something that is needed, and that ultimately there's some good steps towards it, but we're maybe not quite there yet in terms of what it might look like.
Yes, that is correct. I mean, some of it is specific to AI itself, because AI is a very dynamic, technologically and technically complex subject matter. So it requires high degrees of expertise. But some of the problems with regulation, of course, are actually shared by other industries as well. I mean, we have other areas that have had historically specific applications that hinged on highly technical knowledge. I'm thinking about the financial industry and the regulation of derivatives, for example. Financial derivatives are highly complex products that operate on the back of quite advanced mathematical models. And in that sense, there are many similarities with AI, which require, fairly technical knowledge and complex modeling. And the question always becomes, when you have on one side industry, which is able to attract the best people in the field because it can be competitive, and on the other side, a regulator, which is kind of like always trying to catch up and sort of be on par with an industry which is very dynamic, developing and full of also resources, then the risk is that a gap could develop where, in a way, regulation is always lagging behind. That would be problematic and very undesirable. And so I think it is important that when putting together the framework, we pay a lot of attention to some of these points, because ineffective regulation in this field would be doubly damaging. In a way, it would not be able to catch the important things that AI brings about and what needs to be regulated. And in another sense, because it's always lagging behind, it could actually become a hurdle to innovation. So it would be basically the worst of every possible world and not desirable at all.
A lot to unpack there. That is a lot that we will come back to, lots of pins that we'll put to come back into later in the conversation. Racheal, pivoting to you, what we've heard just from Ferdy a few moments ago, that we've seen different approaches across this space. I wonder, what have you seen in your practice, in your experience, perhaps specifically in the UK, EU, maybe Singapore, or even in the US when it comes to AI regulation?
Gosh, well, the past 2 years have just been a whirlwind with advising clients across AI in all of its guises, the deployment in various jurisdictions. As you say, and as Ferdy's correct to say, there is no AI treaty with global effect, creating a standard approach to the regulation, the creation of a legal framework, a legally enforceable framework for artificial intelligence. Geopolitically, the situation, as we've said, is mixed, but they tend to fall in, these countries, the approaches, into a rules-based approach. Now, what do I mean by that? Well, as it says on the tin, rules, a legal framework that's enforceable, that's, one would hope, clear, versus the other approach, a principles-based approach, which is commonly, let's copy and paste the OECD's principles and leave it at that, which, as you can probably hear in my voice, I'm not a particular fan of, for various reasons that I'll come on to. Just by way of context, I have practiced as a quote-unquote tech lawyer for more years than I care to remember, actually, coming on for, I think, 6, 7, 8 years. And throughout that time, as I say, it's concerned algorithmic decision-making across, say, data protection class actions, where data's been misused. And it's something that's at the core, really, of Gen AI, as I said earlier. It's looking at those data sets that have been used. But just segueing forward, something that took up an awful lot of my practice and that I'm very pleased to say I've been recognised for is my crypto asset practice, so cryptocurrencies and non-fungible tokens. And as many of your listeners will know, across the world, again, there's no standardised approach to the regulation of what we call crypto assets, encompassing cryptocurrencies and non-fungible tokens. The result has been that where lawmakers have failed to act and create a clear, enforceable legal framework, I'm afraid nefarious individuals, bad actors, have stepped in, abused the situation, and consumers have lost out. And on a grand scale, we've seen mass insolvency, such as the insolvency of FTX, which I've been instructed in since November of last year. So that the scale of harm in the crypto asset space that we have seen in the absence of a legal framework in many jurisdictions is evident, is self-evident, and I think serves as a warning now for us not to neglect the past and not learn from those lessons, but instead act. Because, for instance, we have the Computer Misuse Act, 20 years too late, after social media harms have been perpetrated. So now, in my view, is the time for a rules-based approach. So starting first with the UK, we have, as I say, a principles-based approach, and that is that the government of the day has said, we want the UK to be an attractive jurisdiction for people to set up shop in terms of AI companies and providers. And so we don't need a legal framework for now. We'll make do with what we have. But here's a bunch of principles. And for instance, we had a Bletchley Park AI Summit back in November, where there was, again, a voluntary undertaking, a declaration, but again, nothing legally enforceable. Strongly contrast that with the EU's approach. As Ferdy says, the EU's AI Act is still in draft. It's been agreed in principle. It seems as though it's going to come into force in 2026. But what does it do? It sets out a legal framework for the regulation of AI, and it does so predominantly by taking a risk-based approach. That is, here is a list of 10 or so practices, not the technology, but practices using the technology that are simply banned. They're prohibited because they're too risky. For instance, intentionally manipulative and deceptive models. So those are out. We can't have those, too high risk. But as for these, and the majority are high risk AI systems, here's a really prescriptive regime of what you have to do if you're going to bring these to market, even if the EU market, even if you're based outside of the EU. So it's prescriptive, but the key is that the EU AI Act has a bite, and that is a penalty. If you don't comply, potentially face a 7% of your global annual turnover fine. Now that could look like somewhere in the region of, I think, 20 billion for the likes of Apple. The fact is the EU's approach is a rules-based approach. It seems as though other jurisdictions are going in that direction. You mentioned Singapore. Singapore has adopted, again, a principles-based approach for the time being, like the UK. So there doesn't seem, although I defer to my Singaporean colleagues, there doesn't seem to be a legal framework on the horizon. If you look at China, actually, the People's Republic of China, they were one of the first to, I think in August of last year, to enact legislation for the creation of essentially a register and permission to deploy AI systems. And I know in the US that you have bipartisan support for a bill and we'll see where that goes. I know that, like ourselves, we're in the midst of preparing for elections. So as with all things, it's all a bit up in the air. But it just goes to show that throughout the world, all these jurisdictions are grappling with, do we leave it at principles, or do we promote penalties and prescriptive approaches if you don't adhere to those penalties? Now, I'm a fan of the latter, as I say, not just because I'm a lawyer, but because I've seen what happens, what goes wrong in the crypto space, as I'm sure Ferdy could attest to in the financial sector, when you don't set the rules of the game. So that's my take on it.
I guess the question that comes to mind after that really helpful explanation, Racheal, is 2026 too late? You know, I asked that question, understanding it takes time to make legislation, and I don't know of any country or any bloc doing it faster. But if we're already aware that AI tools are currently being deployed at sort of an astonishing pace, you know, we'll certainly have elections in multiple countries between now and then. And there certainly will be businesses that, quote unquote, will manipulate the market in some way to their advantage during that time frame. There could even be a situation where the way in which AI is used between now and then affects how this legislation itself goes into force. So I wonder, are we still acting sort of with being a step behind what needs to be done?
I think about 10 steps behind. I really do. As you mentioned with elections, Bangladesh currently is in the midst of an election, and for months now, global news outlets have been reporting about suspected use of deep fakes to promote the incumbent government and other accusations. Look, the fact is, in my own practice, on a very small scale, I've had people reach out to me from all over the world saying, I've transferred all of my life savings, exactly as I heard in my crypto asset cases, because I was very cautious. I engaged with this art agent, for instance. They looked reputable. I did all my due diligence. I then wanted to meet them in person online, just as we are now, because seeing is believing, except it's not. Well, certainly no longer, because it was a deep fake as assessed by our experts. And so the harms are happening now. We've heard in the public domain and the media the kind of existential threats, the concept of robots pressing the nuclear button. But actually, I would say, and I hope, that in fact the threats are, as we've seen in the financial sector and the dawn of the dot-com bubble, since then with crypto, it seems to be Groundhog Day. And I'm afraid, I think we are taking action too late, and particularly in jurisdictions like the UK that has a principles-based approach. I think there's going to be a massive U-turn and a very rushed attempt to regulate, which, as Ferdy said, often bad regulatory regimes can do far more harm than nothing at all. So therein lies the danger. And yes, I think we need to make this a priority, certainly in the UK.
Racheal, you actually teed me up perfectly for my next question, and this one goes back to Ferdinando. I'm going to ask you about a specific example, but hopefully you can use that as a springboard to touch on some of the things that Racheal just talked about or other thoughts you might have here. One of the things that I've spent a lot of time thinking about over the last several months has been this proposed rule out of the Fifth Circuit in the United States. You know, essentially, you know, and I'll read the relevant portion, I won't read the entire thing, but essentially it modifies the rules of court in such a way that says, quote, additionally, counsel or unrepresented filers must further certify that no generative artificial intelligence program was used in drafting the document presented to the filing, or to the extent such program is used, all generated text, including citations and legal analysis, has been reviewed for accuracy and approved by a human. Now, aside from that last couple of words sounding like something out of, you know, the Jetsons or some futuristic sitcom or something, it's a strange rule to me. And I wonder if you have any thoughts, and we'll put that to you first, Ferdy, before we sort of move on from this point.
Well, I think it's an attempt to obtain transparency and clarity. The proposal essentially requires people to disclose the sources of information in the material that they are putting forward. And if indeed the information is coming from a generative model, this needs to A, be stated very clearly, and B, the responsibility of the accuracy of the information stays with the human intermediary, and therefore they have to sort of do adequate groundwork to confirm that information, so much so that they decided to put it forward as part of their documentation. I think in general terms, because it does add to transparency and it puts the responsibility, the legal responsibility on the people drafting the material, I think that it makes sense. Now, of course, with things like that, you can get unintended consequences. And so perhaps people will be, to a certain extent, so worried about potential consequences and making sure that they have an adequate audit trail of all the components of their documentation, that they may actually just, in order to avoid the issue altogether, decide that they will not be using those technologies at all. And that in turn may pose some limitations to the positive development of some of these tools. But nonetheless, I mean, in my opinion, of course, these proposals will go through many refining stages and can always be improved. But the idea in principle that you should essentially disclose how documents and information have been compiled, I think is valid. I think it's valid and is one that I would probably say I support.
Racheal, any comment there before we leave this specific example?
No, I would agree that everything just been said, and emphasize as well, as Ferdy rightly did, the need for those who want to deploy this technology to utilize it, not necessarily in the Gen AI sense, but also for creation of efficiencies in a business, to create that audit trail, to have that as referable. But because should the day come that you're held to account for your deployment of AI and the decisions you took, perhaps you blindly relied upon the output without subjecting the output to significant scrutiny as a living, breathing human being, as legal regimes such as the general data protection requirement require, then you need to be able to show the certain ring fences and safeguards and compliance measures you've taken to check that it's not causing harm to you or others.
Yeah, I think that if I have any criticism of this proposed rule, I think it's probably just a little bit of that I think it's a little redundant to the extent that American lawyers, at least, already have the final liability and culpability in the statements that you make and submissions that you make to the court. So it's, in my mind, the rule essentially says you still have that same liability, but specifically related to AI. Okay? How does that change? What you're already required to do. We've been talking about AI so far, at least within specifically the practice of law, I guess, a little bit more so. I'd be curious to get your thoughts, given your experience. What sort of overlap or sort of knock-on effects do you see in the financial industry or for financial regulations as it goes to AI? Can you share some insights there?
Yes, I think I mentioned briefly in the introduction that other industries, and the financial industry is one good example, have in the past had to measure themselves against specific applications that relied on rather complex, in the case of financial derivatives, mathematical models that were underpinning some of the financial products that were being sold to clients around the world. And from my experience, the difficulty there was that it was very clear, especially when sitting down and meeting with regulators, that most of the expertise and certainly the elements of recent innovation and access to resources as well sat almost not quite unilaterally, but mostly on one side of the table. And the other side was always trying to catch up. Now, that has different effects on people. You might think that if you are in industry and you feel that the regulator is not particularly strong, that sort of empowers you. But actually, ultimately, what that does mean is that you are performing without a safety net, which I don't think is a reassuring thought. Anybody with good intentions who operates in any industry wants to have a strong and clear and fair regulatory framework. Going back to the AI example, I think the most important thing that one needs to make sure when setting a framework, in my opinion, is to essentially find mechanisms for making sure that the quality of the people involved and the technical expertise available at regulatory level is at least as good as the expertise out in industry. Now, that's a very, very challenging and high bar, because obviously the natural tendency will be that there's going to be a discrepancy. But I think that is very important. And unfortunately, I have to say, I lecture at various universities to people who work in technology and financial sectors, etc. And I always ask the same question to these people who are, very good students in very challenging disciplines. How many of you want to work for a regulator when you finish your degree? And I can tell you that, and I have consistent statistics about that, nobody ever puts their hand up. And I think that is where we're getting things wrong. And it will become even more relevant when we will look at AI and regulating AI, because unless you're able to attract competent and talented people, regulation will not be able to keep up with the industry. So that's, I think, ultimately, in a nutshell, what I see as being the biggest challenge.
Well, right. And I mean, it's an issue that we face across, I guess, every place where you have a sort of regulatory issue is how do you attract top talent, make it sort of compelling that, you know, you might be the most talented in the field, but if someone in the private sector is willing to pay you a lot more money and give you a lot of really cool benefits, internal regulations and good compliance sort of things from working as a government employee. I think that those are interesting points. Candidly, do you have any ideas how we would do that? How you would keep people in regulatory positions?
It's interesting. I am reading by complete chance a book called Crypto, which was written actually in 2007 by Levy. And it's not about crypto as in cryptocurrencies, but in fact, it's a sort of historical overview of when encryption and private key, public key algorithms were introduced, and the tremendous struggle between essentially intelligence services and individuals, both in private companies and academia, because they wanted to, once the algorithm was discovered, they wanted to make it public, but obviously intelligence was worried about not being able to chase certain situations, and so wanted to sort of have a hand on it. Well, it's interesting that you might agree or not agree with the attitude of the intelligence services, but certainly for what concerned cryptography back in the 80s, if somebody from the intelligence services sat down with the best people in cryptography in industry, they would have a conversation. They would be on the same level of intellectual engagement. So it is possible to have bodies that position themselves on par with the best in academia and the best in industry. And I think we need to recreate that spirit and make sure, you know, that we are able to create also something where, you know, when next time I go to a lecture and say, who wants to work for the AI regulator? Everybody will put their hand up, but then they will say, but it is so difficult and competitive to get in. And so unfortunately, not all of us will be able to, but it would be fantastic to work for a body like that. I think that's what we should be aiming and striving for.
I think those are well said points. Racheal, sorry, you had something to add there.
No, I hope so too. I hope that we do find ourselves in a situation in future where the regulators are attracting top talent. I speaking to my experience as a very, very junior barrister, sometimes when you're not in court, you're sent in-house to various organisations, and I had the benefit of being in-house at the Financial Conduct Authority, so the financial regulator for the UK. Entirely agreeing with the points that have been said, I'll add that there are superb people in-house. As with any organisation, there are the good, bad, and the ugly. But I'm afraid when you're advertising jobs worldwide for an AI strategist or an AI investigator at the kind of salary bands that are currently being advertised, you are clearly going to lose out to the likes of Silicon Valley. But one does wonder, the time will come where the regulators will turn to AI. Because the fact of the matter is, I'm firmly of the opinion, deferring to all the experts who advise me, that the only way eventually to regulate AI will be by the deployment of models that are capable of doing so. I add the caveat with a superb amount of human oversight. Now, we all have heard the news headlines about, will my job be safe in the age of AI? And clearly, in my view, although Ferdy's the expert here, there will be significant socioeconomic upheaval in the years, the decades to come, maybe sooner, when there is that loss in the labour market, that shortfall for a time, and then the creation, one hopes, of new forms of employment. But in line with efficiencies that can be brought in with AI, one hopes it will empower the regulators. But it's self-evident there needs to be that funding from centralised governments for regulators. But when regulators work well and efficiently and have that expertise, they can do amazing things. And I, of course, have a vested interest. I'm instructed by a well-known regulator in the FTX insolvency. And I would say this, but I genuinely mean it. My client is superb and has done a fabulous job stepping above and beyond the call of duty for any regulator has done in history. So it can be done. But again, the time is now, and we need investment now.
There you have it. Plenty of threads to pick up on from that first part of the conversation. Can we regulate AI? Will governments have the courage to act boldly and swiftly? And even the age-old question, is AI coming for your job? We hope that you enjoyed that first part of the discussion and that you'll come back for the rest of it. If you enjoyed the conversation, let us know about it via LinkedIn or drop us an email. And if you want to know more about ArbTech and its initiatives, head on over to the ArbTech website. Finally, Tales of the Tribunal is returning from its winter break with Disputes Digest during the second half of February, and a new season of the show and its interviews coming in the spring. But before all that, we'll say farewell for now, and until the next episode, where we'll come back with Racheal and Ferdy for more. Thank you for listening. This has been Disputes Decoded. You've been downloaded.